Welcome. I'm John Henry, Chairman of the Committee for the Republic. Our battle cry is, America will never be great again until the Constitution is great again. And the Constitution will never be great again until Congress is great again. Tonight we have another salon on how we went from constitutional abundance to constitutional scarcity with the accumulating power of the office of the President of the United States. Presidential wars, of course, top the list. In December, we reviewed more than 170 impeachable offenses that have gone unpunished over 180 years. In February, we reviewed an avalanche of executive orders. On April 10th, we're going to examine the obligation the Constitution imposes on the President to faithfully execute the laws. But tonight, we are examining presidential abuses of the pardon power. September 17th, 1787 witnessed a miracle in Philadelphia, the birth of the United States Constitution. For the first time in history, a federal government is constructed on the foundation of separation of powers. For the first time in history, the executive is denied the war power. A republic, as Franklin warned, if we can keep it. Separation of powers is the bulwark of the Constitution. A Hemingway character in The Sun Also Rises was asked how he went bankrupt, and he responded, 2 ways. Gradually, then suddenly. That description aptly fits America's plunge into constitutional bankruptcy. The steady and now rapid erosion of separation of powers has turned our Constitution into a scrap of paper. Just how did we go from the rule of law to the law of the jungle? When it comes to the Constitution, our 2 major political parties have been summer soldiers and sunshine patriots. Democrats and Republicans have, as Dick Cheney said, other priorities. When they occupy the White House and get the policies they like, they are Wilsonians and don't worry about the Constitution. It is only when the White House is lost that lip service is paid to the rule of law and they claim to be Madisonians. I ask you this. When are we going to stop voting for Democrats and Republicans who put the policies of their party ahead of the Constitution? Can we stop selling our soul to feed our addiction for empire? The President's pardon power has been turned on its head. A paramount purpose was to offer insurrectionists pardons to quell a rebellion. Now it is used, among other things, to reward insurrectionists after their insurrection failed. It was expected that presidential pardons that sheltered family or political cronies would provoke impeachment by the House and conviction and removal by the Senate. Now, in a page from Alice in Wonderland's Mad Hatter Tea Party, a president pardons his son for crimes prosecuted by his own administration on the preposterous theory that he treated his son unfairly. Over the course of a lifetime of intense study and scholarship, Committee Vice Chairman Bruce Fein has sounded the alarm against jettisoning the miracle of Philadelphia in favor of the same old limitless executive power which provoked the American Revolution. Why did the framers assign this power to the President? Does it contradict the President's constitutional obligation to take care that the laws are faithfully executed? Where are the recent abuses of the pardon power leading us? I know of no one more qualified to answer these questions than Bruce. It's all yours, Bruce.
You have to remember that all effusions of that sort are not said under oath, so you're entitled to exaggerate. Now, The pardon power, I believe, is especially important to examine because it's the one case where presidential abuses really are not subject to any kind of judicial review. No one would have standing to challenge what's claimed to be an illegal pardon. And so it underscores the importance of we the people and the Congress to police the pardon power. It's not going to be the courts. And indeed, when George Mason at the Virginia ratification debates explained that he was very troubled by the pardon power because the president could use it to pardon his friends, shelter his personal family or otherwise, Madison explained no, the House of Representatives would surely impeach him and he would be removed from office. That was the guardrail. It wasn't the court. And we can see how irrelevant the Congress is today to exercise the impeachment power to police the abuse of the pardon authority. The pardon authority, in some sense, is in tension with the president's obligation in Article 2 to take care that the laws be faithfully executed, because they're saying even if you violated the law, you don't pay really much penalty. The pardon doesn't wipe out the conviction, but it wipes out any consequences that are served from that conviction. Now, I want to give you a hypothetical that shows, and the pardon power has been abused by Democrats and Republicans alike. You remember that Mark Rich and Bill Clinton is just one example, but you had others. Remember, you had Mark Felt and Miller, they were FBI agents who burglarized, and you had those involved in Iran-Contra who were pardoned. It goes back a long way, but never, I think, as systematically as we saw, I guess, with regard to Biden and then Mr. Trump, where with Congress no longer exercising any policing power, it can take you into a rather frightening realm. Right now, a president could tell a subordinate, why don't you go assassinate my enemy? I'll pardon you right afterwards. If Congress isn't a threat to impeach, what would inhibit a president from doing that? We know that earlier in a term, President Trump suggested to an immigration agent, well, you can go ahead and violate the, I'll pardon you on the southern border of Texas. I mean, that really is quite frightening because it means you basically have a private presidential Gestapo, if you will. You pardon anybody, say, just promise them pardon. You don't have to comply with the law anymore. And again, I underscore that the framers recognized if Congress isn't going to do the policing power, that is really where we are right now. Now, people say, well, it hasn't happened yet. True enough. But the whole reason why we have checks and balances and the impeachment power is to stop you and the country from falling off the cliff before it's too late. It is prophylactic, not after the fact trying to redress something that's already created peril to our system of government, which clearly would be the case if you have a president saying to all his subordinates, the FBI, go ahead and commit whatever crimes you want. I'll pardon you all. And that's where we are at present. That is a true possibility. And I say it's not limited to Trump. No president in history has ever surrendered power that he inherited from his predecessor. Whoever comes after Trump is not going to yield anything back. It always ratchets only one way. This underscores, I repeat, the importance of we the people. We are the last guardrail. Congress is not going to do this unless they feel they're going to lose office. And they're only going to feel that way if you write in, complain, Republican or Democrat, if you don't exercise your constitutional responsibilities. You're the overseer of the pardon power. You're not going to be returned to office. It does work. I remember said in Saturday Night Massacre when President Nixon suggested he would not surrender White House tapes to a grand jury. 30,000 telegrams coming in every day for 5 days. The president changed his mind. And I was there in Congress in 2013. President Obama wanted a declaration of war against Syria for alleged chemical weapons use. Everything that came in, no, no, no. Even the super hawks like Ted Cruz would not support a declaration of war because of that massive outpour. And I remember also the first TARP vote, the Troubled Assets Relief Program. to bail out all the banks, the big banks, because of their reckless lending, and all the homeowners could pick up the bag. The first vote in the House, the reason why it went down is because it was overwhelming. Emails, faxes, letters, phone calls. People ask, well, what can I do? I just don't want to be an observer on the scene. Even if your own opposition seems small, maybe inaudible, collectively, that's how democracies and self-governments operate. We all do our own part. But silence is not an option if you want self-government. And unfortunately, that's where we are today. Now, we understand that because of the polarization, it's often risky to speak out. You're going to be accused, you don't like that, you're unpatriotic, you're a terrorist. I mean, the ordinary ad hominem attacks that you can already anticipate. But there's one element, there's one characteristic that perhaps is more important, or at least as important in separation of powers, to make a republic work. It's called courage. Aristotle applauded it as the summit of virtues because without it, none others are possible. And I remember John Adams, our second president, before we achieved our independence, there was a fray called the Boston Massacre. And there were 8 British soldiers, among others, were charged with murder. And John Adams defended the British soldiers. He thought they were innocent, it was the right thing to do, and they were acquitted based upon his advocacy. He was threatened, and his wife and his family were threatened with death. This is terrible. How could you defend these horrible, horrible redcoats? And Abigail Adams wrote John, said, well, it's true. I feared for my life, so did our children, but we're glad you did the right thing. John Adams later reflected, it was his finest hour as a lawyer. And you can see that's a risk that lawyers, including me, have to take today. Under the current practices, you could wake up in the morning and executive order says, we've banned you, you can't enter federal buildings. Anybody who works in your firm can never work for the federal government again, you lose your contracts, and that sort of thing. Now, I want to underscore that really what we see that's overt with the executive orders, in the past it's been done kind of covertly. Everybody knows how Washington works, and you don't have to be expressed that they end up doing favors, because there's so much discretion, certainly in law enforcement, to their friends, those who think that they're on the same side. Politically, they have their own. There's a Republican network and a Democratic network. But this really does take it to a new level, where it's totally and overt that you're being threatened, that you will lose clients and access to government agencies that are essential to perform your work, unless you do something for the president. In one instance, $40 million worth of pro bono services for the causes he likes. Well, that's his preference, but what happens? You're going to have another president in there as well. And that's, I say, an example of where the lawyers have to be the first responders, I believe. But the citizens are the ultimate first responders by calling in. And also, it means educating yourself more about the Constitution and the history, because an educated opposition is going to count more than just one line, do something. It's showing that you understand what you're saying and why you have the courage of your convictions. And that's how we recover the miracle at Philadelphia. I oftentimes say, myself and everyone in this room, we all won lottery tickets. We're very fortunate to be in the United States at present. As decrepit as the Constitution is, I can tell you, being around the world is better than any other place, as inferior as it's become over the years. We won lottery tickets, we have an obligation, to try to preserve and bolster the freedoms and liberty for our posterity. That's the way in which we express gratitude for the 56 signers on July 4, 1776, who signed their death warrants for government by the consent of the government and unalienable rights. We have to be as courageous as them. Otherwise, it's just a matter of time. We're going to end up back with the king can do no wrong and the same path as the Roman Empire. But I can go, with regard to particular pardons, I wanted to address things philosophically, but I don't know how you want to address the pardons that most recently are outrageous, like Joe Biden's pardon of his son, Hunter, after he pledged he wasn't going to do it, and then he makes a statement, well, my own administration was so unfair towards him. Well, then why didn't you intercede? You're the president. And then Trump's pardon of all the January 6th defendants. And now he's even considering, he wants to pay them money, restitution for whatever. That's on the table now. That's really takes this to a new level, right? So that's where we are. And we know that, at least at present, Congress is inert, it's craven, will not do anything unless it feels it will not be reelected because they're constituents. And that's us. The other thing that I want to say is that even if in the short run we don't succeed, and oftentimes change takes generations. We can think how many people sacrificed to get rid of Plessy and Ferguson and separate but equal, 1896, this is 58 years. A lot of people were murdered, killed, and whatever, but they struggled and kept at it. Now, sometimes change comes more rapidly. We don't know. Life is very contingent. But the one thing that's unforgivable in a self-governing republic is to fail to try. And that's where we are today. But I take any questions, John, or you want to ask any?
Come on, sit down. Questions? Does anybody have thoughts? Before I initiate your life? Discuss.
Yeah.
You go first.
Do I need a mic?
So I'm wondering,
We'll get you a mic. We'll get you a mic.
can people announce themselves?
Sure. Say who you are.
Thank you so much, Bruce. Can everybody hear me?
Yes.
You mentioned the word silence in your opening statements, and you've also mentioned citizens. Where are the other institutions like academia, think tanks, and the private sector? They are so dependent on federal funding, like Columbia's $400 million. So they have to become corporations, and think tanks have become lobbyists. And I'm very, very concerned, and lawyers are caving in. So we really don't have any citizenry in this country at the moment.
Well, the observation is very astute, but let me broaden it. The more tentacles that any government displays, the more inhibited and self-censoring corporations and even individuals will be, because they feel that their financial destiny depends upon staying in the good graces of the government, especially because it's inherent in a regulatory state that there be enormous discretion. You know, whether or not a drug is satisfied, safety and effectiveness, how many tests have you done, what's the margin of error, things like that. When you have public interest standard to approve a merger, that could be very, very important to the particular financial standing of any particular company. And what happens is when the government gets bigger and bigger, and I've seen that talking with clients, said, Bruce, yeah, it's a violation of free speech, but I need this regulatory agency, to go and approve X, Y, Z. And the Federal Communications Commission, it happened all the time. We wanted to get a transfer of a broadcast license. I can't say anything that's negative about somebody who has that discretion. Because I can tell you with the FCC, public interest standard, you could deny or grant whatever you wanted to do. It's so amorphous. Which is a reason not to say we don't want government, that we have to recognize that despite our most benevolent ambitions and hope to improve upon just free markets, because we know human nature being what it is, it's not a perfect existence that we have without any regulation. That are you creating a cure worse than the disease? Because you create such self-censorship and inhibition, and all those who now depend upon government action to flourish, they just won't speak anymore. And that's what you see at least a little bit right now in the legal community, where now it's a mixed message as to whether or not they're going to capitulate to what Trump is demanding, boycott certain clients or whatever. It's not been, some have been more robust than others. Paul Weiss kind of capitulated, I believe. We don't know where it's going. But that's always a danger. I mean, I don't have any contract with the federal government. What the heck do I care? But big firms do. And their voices are important, and they should be uninhibited, whether they want to support or oppose a president. And that, say, it becomes compromised the bigger the government is. As an example, I remember the Supreme Court has given very, very powerful protection to commercial speech. And commercial speech is something that drug companies exercise all the time in trying to promote their products. Now, I'd say, gee, all these FDA regulations, half of them, it's like the FEC, half the regulations are clearly violating the First Amendment. They say, Bruce, so what? I cannot afford to speak out and then have them sit on my proposed drug to get approved to be sold for billions of dollars, for 5 years. I can't do that. So I'm not going to say anything at all. That's just one example of how the self-censorship works. The bigger government is. And that's what we're witnessing at present. And you'll see the same. It's not just Columbia, Penn, all these universities. They have so much money that they're going to be inhibited in standing up for academic freedom. And that's a reason why you want to keep government as small as possible, not because the private sector is perfect, but the government cure ends up being worse and destroys the republic.
Right there.
Hi. So Loretta Green, I was wondering if you could comment on the idea that Biden used, like the controversy over it was an auto pen. Rule of law is about witnesses, notary republics. Was it done in a proper fashion for the pardons that Biden did? And so is there any legs to that argument about the auto pen?
Well, the president needs, obviously, to make the decision. Let's go in an analogy where Woodrow Wilson was incapacitated for many, many months, maybe over a year, after he collapsed promoting the League of Nations. So his wife would talk to him, and she would basically de facto behind the scenes make the decision. But we assume that as long as the president says, yes, I understand what's going on, and here's the paperwork that needs to be done to have it concluded. That's the important thing, is we know that nobody is sacrificing the ultimate decision maker, the president, and substituting it for what would be a different decision if the decision maker made it. Now, I don't know at present, President Trump has said that Biden didn't know what he was doing. That's a different matter than whether it was an auto pen. Because it was just like if Woodrow Wilson was totally deranged and the wife was just making up, he said, do X, Y, Z, that's a real problem. Unfortunately, given executive privilege, it's oftentimes to know exactly what's going on there. But that's really the issue, I think, that's raised with regard to the auto pen.
Hi, back here. If you can hear me. Yes, Ann Wilcox. I work with the D.C. Bar, and there is an election coming up. Anyone who's a bar member in this city, a member of the bar, there are candidates closely aligned with the DOJ who are running for bar leadership. So I just want to raise that as a possible concern of taking over institutions that should be independent, in terms of professional review. And thank you for all you do for whistleblowers, Mr. Fein. Thank you. And you can talk to me about the election.
Yeah. But these are, it shows you have to be active. I mean, I don't deny, if people want to come out and vote, even if I disagree, they have a right to vote, a right to campaign. It's up to us, if we oppose that, to take action itself and campaign and advocate for something different. That's how the system works, right? The process is so critical here.
We have a question.
Can you hear me?
Yeah.
Okay. I'm curious, Mr. Fein, what's your opinion on the Judge Boasberg situation where he's seemed to have gotten a few cases where he's going squarely head to head with President Trump? Do you see an end to that, or where do you think that's going to end, if at all? Okay.
I think the audience, just as background, in 1798, Congress passed the Alien Enemies Act, when we were basically de facto at war with France, that authorizes the president, without customary due process, to deport alien enemies of countries in which we have a declared war by Congress, or that country has actually invaded the United States. Today, mean using drones, dropping bombs. Okay. Now, the 1798 Act was never used by John Adams to deport anyone, right? Never. It had been used 3 times in World War I, War of 1812, and during World War II, when Congress, in fact, had voted to declare war. Unfortunately, I mean, World War II, it really wasn't utilized in a very responsible way. President Roosevelt used it in part to incarcerate 120,000 loyal Japanese Americans. They rotted there for 3.5 years. We celebrated those who had the courage to challenge the legality after the fact of their convictions of the executive order, putting them in the concentration camps. In 1988, Congress passed the Civil Liberties Act that said everything we did and Roosevelt did was flagrantly unconstitutional. It was an act of racism. Here we're giving you reparations. So the act does not have a happy history, but in any event, it's limited to times of war, either a declaration by Congress or an actual invasion. President Trump decided he would, on his own, he would declare that a Venezuelan gang, and I think the total number is like 600. They're spread out, I think, in about 14 or 15 states. You got about 40 in each of them. That this Venezuelan gang was engaged in warfare against the United States. Now, we know that there hasn't been a declaration of war by Congress. Indeed, there hasn't been since Pearl Harbor, December 7th. So the argument was that this gang is really running warfare for Venezuela against the United States. We're engaged in a military exercise. Now, I don't think most people feel that we're at war. These people may be engaged in criminal activity, but that's not synonymous with war. And there isn't any evidence. In fact, the CIA did it and was tasked, what is the connection of this Venezuela gang to the government of Maduro? Said, no, it really doesn't. They're not acting as his Gestapo. In fact, many of them are prosecuted back in Venezuela. But putting those uncomfortable facts aside, the president said, no, these people are, Venezuela is attacking the United States. And therefore, he then he captured those who he said were members of the gang. The way that they decided that they were members of the gang was whether they wore tattoos. Now, obviously, some people wear tattoos if they're not members of gangs. You probably know friends. That's just commonplace today. Anyway, they put them on airplanes and were sending them to El Salvador because Venezuela, at least initially, didn't want them back. El Salvador agreed if we paid them money, they would take them and put them in the Salvadoran prisons. But Judge Boasberg ruled that, at least preliminarily, that there wasn't any evidence that we're at war. Of course, we're not at war, and certainly there's no congressional declaration, and that the government had put in no evidence showing tying the 600 Venezuelan gang members, to being a military force of Maduro. But then what happened is when Judge Boasberg said two things. One, I want to know when the aircraft left with the deportees to see whether it took off after my order said, no, we're freezing the status quo. The government has not responded to that yet, although the indications are it will plead executive privilege, state secrets, and say we're not going to tell you when the aircraft left. The second thing that they're arguing is that when the president says they were at war with a group, it's conclusive. That you can't even ask that evidence be submitted, what the lawyers call in camera. In camera submission means you share it with the court, but no one else sees it. If when you have sensitive information. No, that's out. You just have to take our word for it. That's conclusive. Now, the judge kind of raises his eyes because that's rather an extravagant argument to mean that the president, under that theory, could say everybody in this room is a member of Venezuela, paratroopers or whatever. You can't second guess it. Hey, well, ships us off to El Salvador. Now, we know there are political constraints, but at least in theory, that's where the logic occurs. So Judge Boasberg issued a preliminary injunctions against the administration, and now he's trying to investigate whether or not there was any violation of his order. In the meantime, the government went to the U.S. Court of Appeals for the District of Columbia Circuit and argued that lower Judge Boasberg erred. Yesterday, the Court of Appeals rejected the argument, said no, Judge Boasberg stays undisturbed. One of the judges said that the Nazis during World War II got more due process than those who were shipped to El Salvador based upon being a gang member. We don't know exactly, how many are actually members of the gang because we've never had a trial. I'm sure that there are probably some, But the whole reason why we're civilized is that we think justice is individual and guilt by association went by the boards with Thomas de Torquemada, and we don't want to return to that era. So the administration now may, if it wishes, go to the U.S. Supreme Court and try to get a halt to what Judge Boasberg is doing. Now, we know in the interim that after Judge Boasberg issued his initial decision, there was a cry for his impeachment and removal from office by Trump and by others, saying, this is terrible, you're usurping executive power, and you need to be impeached. After that threat was made, very unusual, Chief Justice John Roberts, who I happen to know and helped him in his career at the Justice Department, issued a public statement, quite rare, saying impeachment is not what you do if you disagree with a judicial opinion. There's the appeal process. Now, at the earliest stages of our Constitution, there was an effort by Jeffersonians to impeach Samuel Chase. He was a Supreme Court justice. He didn't like some of the things he said about the Sedition Act. Justice Chase was acquitted in the Senate, establishing the general understanding that you don't impeach and remove judges for wrong decisions, you do appellate review and seek to have it changed in that way. That if there's to be impeachment, it should be for what the Constitution calls bribery, treason, high crimes, and misdemeanors, not errors, judgment in your office. So I think the Chief Justice gratuitously made that statement because he saw a threat to the independence of the judiciary coming down the road. We do know that there have been, I call them trial balloons, where J.D. Vance and Elon Musk have said from time to time, we really don't have to comply with the court judgments if we don't want to. Trump hasn't gotten that far expressly, but his subordinates have flirted that idea. It's not been received well in the legal community, or I think by the judges. There was an op-ed, one of our prior speakers, Judge Michael Ledick, in the New York Times saying, no, the court is not going to surrender their power of judicial review to the executive branch. But where this falls out, we don't know right now. It really has never happened before. There have been assertions that President Abraham Lincoln and Franklin Roosevelt flouted court orders. They're simply ahistorical. With regard to Franklin Roosevelt, no, he did not flout a court order, even the Schechter-Poultry decision throwing out his flagship program, the National Recovery Act. He didn't like the decision, but he didn't disobey it. He then tried through a way that was it wasn't quite defying a court order. He proposed his court packing plan to increase the number of justices from 9 to 15 so he could appoint 6, and he thinks he could get a favorable majority to rule in favor of the National Recovery Act. But anyway, that's what he did. I don't applaud the attempt to pack the Supreme Court, but it wasn't, whatever else it wasn't defying a court order. Abraham Lincoln, when he was president, when Fort Sumter was fired on, he suspended the writ of habeas corpus unilaterally without Congress's authority. Congress was not in session at that time. This was April, I believe, 20 or something of 1861. Chief Justice, a circuit judge, Chief Justice at that point, Roger Brooke Taney. There was a time up until the 1890s where the justices of the Supreme Court not only sat as the appellate judges at the highest court of the land, they served from time to time as trial judges on circuit. And he ruled in a case called Ex parte Merryman that only Congress could suspend the writ of habeas corpus. And Merryman was someone in the Baltimore area, and there was worries that some of the Pennsylvania troops coming from the north could be intercepted by Confederate sympathizers. So what Lincoln did with regard to the circuit court decision, he didn't comply. He goes to Congress and says, you need to ratify what I did. He says, I don't have authority to do that, but you do. You can suspend the writ of habeas corpus. And Congress did that. The Habeas Corpus Act of 1863 ratified everything that Lincoln did. And he said, so it kind of mooted that issue. Although he got close, but he said, but Congress wasn't in power. Congress is the only authority to suspend habeas corpus. So that's how Lincoln handled that. So there's a third case that is sometimes raised, and I'll broach it just so that you'll know the complete background. It concerned President Andrew Jackson in a case called Wooster against Georgia. There was much hostility towards Indians because of the craving of the white settlers for their lands and some of their minerals. But the relationships under the Constitution that existed between the federal government and the Indians were exclusively federal. It wasn't an issue for the states, and we in fact created treaties between the federal government and various Indian tribes. And we had such a treaty with Cherokee in Georgia. So there were two missionaries went down and without seeking any Georgia state licenses did their work on the Indian reservation. So the Georgia authorities were angered and they prosecuted them for not obtaining a license. The case was taken to the U.S. Supreme Court, and it was argued that Georgia had no authority over the relations between the federal government and Indian tribes and couldn't limit what the federal government permitted. Chief Justice John Marshall agreed with the missionaries, said, no, Georgia law is preempted by the federal treaty relationship with the tribe. Andrew Jackson reportedly said, John Marshall has made his decision, now let him enforce it. But that was premature. There was never, what happened was before the issue ripened to a challenge, South Carolina began to be restive about federal revenue tariff laws. And they were passing resolutions saying, we're not going to comply with the tariff laws, which would cripple the federal revenues because it was the majority way in which the federal government operated. Andy Jackson then changed his mind about federal authority. Okay? So what happened is they did a political solution. The governor of Georgia pardoned the defendants, and in exchange, the defendants then dropped their case in Worcester against Georgia. President Andrew Jackson then backed South Carolina down by saying, he passed a bill called the Force Bill that said, you don't collect those revenues, I'm going to make the Battle of New Orleans like a tea party. So South Carolina said, okay. So that's how that was resolved. So the fact is that never in 230 some years has any president defied an order of the United States Supreme Court. So we're now perhaps into terra incognita. As a matter of raw power, the marshals are part of the executive branch. There's nothing that can compel the president to comply with a court order except us, popular opinion, Congress, the impeachment power. That's it. Technically, if you want to run roughshod, there are no guardrails. You can't. If you have somebody who doesn't care and was willing to use force, it's here to the strong do what they can, the weak suffer what they must. Courage is the only last result. You can talk all the world about parchment paper, but it's not going to save you.
Good. Here we go.
That's sobering. First, I'd like to say thank you for this forum. I really appreciate it. And my question is simple. Can you just speak to the preemptive pardoning power as it relates to the Constitution?
Yeah.
You're next. Thanks.
Well, it's certainly something that the framers never contemplated because it's a very odd creature, if you will. And let's explain what happened. I'm less concerned about the preemptive pardon power than the power I described saying, you know what, go commit crimes, I'll give you a pardon. The preemptive pardoning power, the first time it's ever utilized was Joe Biden. And basically he said, I think that Trump may go after my family, some others, Liz Cheney, so I'll pardon them in advance of any crimes that may have occurred, prior to the issuing of the pardon. Now it's ill-conceived, I believe, in many ways. If you're trying to protect them from so-called retaliatory prosecutions by Trump, it doesn't work because a pardon can only pass for things that have already happened. If you want to make up a crime, you're a terrorist, money laundering, tax evasion, whatever, yeah, you're easy if you don't have to comply with the law. So I think it's kind of a phony protection anyway. And moreover, the idea is if you give a pardon, you must have some good faith belief that there's a crime been committed. You just don't start throwing them out on the sidewalk like candy or something to kids. And there's another reason why they are very, very dubious. Suppose the president and anyone in this room said, I'm pardoning you for child molestation. You say, what? Why did it stigmatizes you, right? It says, yeah, you committed a crime. So that is a way in which he can destroy your reputation, which is why these pardons by Biden, I thought, were outrageous. And some of the recipients said openly, I'm not accepting the pardon. You can't force a pardon on somebody. I didn't do anything wrong. I'll comply with whatever laws there are, and I'll rely upon due process and the rule of law to save me. Yeah. So, I believe that one of the reasons why, Trump, and his successors say, I'm not going to really denounce these because I'm going to do the same thing to my people and me before I leave office. So it's a very, very terrible precedent. To be candid, I don't believe the framers conceived it would be so abused. And they viewed the remedy, because withstanding is impossible, to be impeachment and removal, which now, unfortunately, because Congress is craven, is a scarecrow.
Phil Pasquini, I'm a journalist. When President Adams signed the 1798 Sedition Act, it had an expiration date in 1901. Can you explain how it's still applicable if that was the case?
There was the Alien and Sedition Acts. The Alien Act stayed. The Sedition Act expired of its own terms, and I think it was 4 years. Anyway, it was when Jefferson took office, he pardoned everybody convicted of the act, and Congress remitted their fines. But the Alien Act was different. But it was never utilized by John Adams. He did not deport one person under the Alien Act.
Bruce, when you talked about the district court decision and went up to the Court of Appeals, I think that the decision was 2-1, I believe, out of the Court of Appeals.
Not on the merits. The dissent said this case should be in Louisiana, not here. That was what the dissent was.
Now, could the Trump administration ask for an en banc review of the Court of Appeals rather than go to the Supreme Court?
It can do both. As a litigator, if you lose, just to explain to the audience, if you're not lawyers, when we have these courts of appeals, typically they vary in size because the caseloads depend upon the geography. California is more than Montana. But typically the courts of appeals have anywhere between 15 and 20 judges. But when you go up on an ordinary case, you get a panel of 3. If you lose to the panel of 3, you have 2 options. You can ask for a rehearing en banc, which means all the judges sit, or you can go up immediately to the Supreme Court. But even if you ask for a rehearing en banc and you lose, you can still go to the Supreme Court. It's not like you have to choose one or the other.
Do you know what they've done?
I do not know that the decision is so recent, they may be pondering what their next avenue. But they certainly, in the past, they've gone now 2 times to the U.S. Supreme Court asking in different cases for stays, and the U.S. Supreme Court hasn't acted on them.
Now, another issue that's out there, like I pay a lot of attention to, is that the district court decision that can apply across the country. And there's a lot of interest now in, and I think Elena Kagan has been quoted as saying that's not a good way for the district courts to behave. And I'm seeing that a lot of the Republicans control the House and the Senate. They could pass a law to restrict the district courts and take that power away from them from nationwide
injunctions. Yeah.
Yes. Do you think that's a good idea?
Well, I don't know. I think there are arguments for it and against it. Remember, why do these nationwide injunctions exist? It's because the defendant is ordinarily Secretary of State, can be the President, it can be Secretary of Defense, and they exercise authority over the whole country, right? And so if their action is being challenged as illegal, you'd say, okay, if I'm enjoining that officer with nationwide jurisdiction from doing something that I think runs contrary to the Constitution. Now, the argument against it is, well, but it's just one district court. Why should it shut down the whole nation? Because other district courts may disagree. They don't haven't had opportunity to weigh in on it. And so if it's an error, it's a nationwide error rather than a narrower error. I don't know. I'm not strongly in favor of one or the other. But Congress clearly has the power, if they want to limit its remedial power, the judge's remedial power that way, to do so.
Yeah, I think it's important for people to understand not what the Constitution sets up the Supreme Court, but it doesn't create any of these lower courts. They're politically created by the Congress.
Yeah.
So they can do a lot of fooling around with this whole judicial system.
Pat, it would be constitutional for the Congress to abolish all the federal district courts and say, what we're going to do is have state courts and then go up to the U.S. Supreme Court. I'm not saying it's a wise idea, but constitutionally, that's what they can do.
Yeah.
And just, again, as a historical fact, that when Congress initially created the federal district courts, they had no jurisdiction over constitutional issues. They only entertained disputes between citizens of different states under state law. It wasn't until 1891 that they were given federal question or constitutional jurisdiction.
Were they given it by the Congress?
Yes, they were given by the Congress in 1891.
I didn't know
Yeah.
that.
Bruce, Nina Randolph. I just am wondering, you know how the Constitution was created and so much thought was given to it. How did our founding fathers leave these loopholes? Have you read anything about the conversation about a authoritarian government, the loopholes with the court system, the district court system? Can you give us some background about how we could possibly be in this position?
No, I think that the framers knew two things. One, the system doesn't work without an educated public. In fact, that was the most important message of George Washington's first State of the Union message. We need citizens who understand the Constitution, will defend it. If it's imperfect, it needs to be amended through the proper processes of Article 5. They couldn't, the other thing that the framers, I think, missed, because George Washington was such an overwhelmingly popular political figure. Remember, he won 100% of the electoral votes twice. 100%. That, and everyone who's involved in drafting the Constitution, they knew George Washington was going to be president, and they trusted him. You know, said this: George Washington wouldn't do these things, and they were right. He didn't do these things. But because of Washington's dominance, the natural tendency of political parties, like the Tories and the Whigs in Great Britain, were suppressed, and they didn't see how polarizing and loyal the parties would be to their own party's fate opposed to the Constitution. That is, they conceived that the institutions would protect their own prerogatives irrespective of party. That is now broken down completely. The Republicans don't care about, in Congress, their powers as long as you've got a Republican president. The Democrats the same way. And it is that party system against which George Washington warned that has led to the erosion and destruction of separation of powers, which is why we are here today. There aren't any checks anymore on a limitless executive. And if one thing that the founders agreed, you have a limitless executive, that's the way every single prior republic has been destroyed. And Rome was a perfect example. So you could fault them for saying, you didn't understand how political parties were going to develop. They understood factions. James Madison underscored it in Federalist 10. But they're nothing like we've seen or witnessed today. And even at the outset, the polarization was modest compared to what we now witness. The number of, when Jefferson came in to replace John Adams, the Federalist president by Republican Democrat president, he replaced very, very few civil servants. The continuity was great. There wasn't really any large displacement of civil servants. It was almost like the British system until Andy Jackson came in, and that's when the jingle, to the victors belong the spoils. But up until that time, everyone understood this is a merit system. We don't discharge people just because their political loyalties are different. We expect them to comply with their obligations and follow directions. But to say that's just not at all what we witness today. And I wouldn't call what the framers missed as loopholes. It's just that they didn't have perfect perspicuity on how our political system would develop. But they understood that you can't have a constitution that's 80,000 pages long but try to get with any kind of deviation. You have to write in kind of large strokes. And what they believed was that insofar as the details are lacking, Congress will step in and remove people who really are not faithful to the Constitution and the prerogative that they're discharging. That's why they believe that for a very simple reason. The impeachment and removal power is a very civilized, mild rebuke for constitutional violations. You don't go to prison. You don't get sent to Siberia. There's no guillotines like the French Revolution. All that said is, we cannot trust you as being a loyal steward of our liberties. Go and do something else. I mean, the closest we got to removal was President Nixon's resignation in 1974. But he actually became almost a popular statesman afterwards. He didn't suffer anything, you know. People never said, well, I could never want to be like Nixon, you know, like King Louis XVI, who gets beheaded with Marie Antoinette in the French Revolution. That's not what impeachment is about. It's what Ben Franklin said. It's a civilized substitute for tyrannicide. We get rid of the dictators, but in a peaceful way after there's evidence and a trial. And somehow, I believe that the ordinary person believes that impeachment is just kind of a wild, radical phenomenon like the French mobs in the storming of the Bastille, you know? It's not. But again, that comes because we're so constitutionally illiterate. And on that score, and this is kind of gratuitous, in the last few days, you probably read streams of information in the newspapers about this signaled discussion of all these high-level officials in the administration about attacking the Houthis. And one of the participants was one, Tulsi Gabbard, and I helped write, John, a committee supported Tulsi Gabbard, for sponsoring and introducing a bill that would make presidential wars unconstitutional and impeachable offenses when she was in the Congress. Now she's on this conversation with all the others. The Houthis? We're a declaration of war against... Where's the authority to be attacking the Houthis? Aside the fact that we probably killed more civilians than Houthis. And the Congress hasn't even passed an authorization, an AUMF, which is a delegation. Nobody on that phone conversation, and not a single word in the massive coverage of the New York Times, the Washington Post, the Congressional hearings, Wall Street Journal, ever said, wait a minute, how can we be at war when we don't have any congressional action? Isn't this a violation of the Declare War Clause? Not a single word. And these are the highest level people who are running the government. That shows you how deep constitutional illiteracy runs.
Hi, Bruce. It's Tom Hanshaw. I just want to ask you about this Paul Weiss agreement, because the impression I have is that, you know, they've caved. They were with the Democrats, and you get the impression that Trump is basically trying to erode all sources of resistance. And to me, this is a really important development, and it looks like at least part of the legal establishment is caving to this executive power. So I wanted to get your thoughts on that, and whether you think this is part of a general trend that is concentrating power that's ultimately going to lead to a quasi-fascist state like Italy in the 20s and 30s, or Hungary. Anyway, I wanted to get your thoughts about how you saw this in the context of executive power being increasingly centralized in the White House.
Well, that's just one phenomenon. I think that, to my view, there are many earmarks of abuse and fear. And they say the worst one is the war power. Yeah. In times of war, the law is silent. We saw what happened to the Japanese Americans. There is no law in times where everything is national security. The Fourth Amendment goes out the window, spy on anybody you want, kill anybody you want. As we sit here today, at least since 9/11, every president has asserted the power, and we don't know how often exercised because it's all cloaked in secrecy, to play judge, jury, prosecutor, and executioner to kill anybody he wants, anywhere, U.S. citizen or not. We know one of them from a leak was Anwar al-Awlaki's teenage son, exterminated, vaporized in Yemen, having dinner. We don't know because the state secret's privilege, how often it's been done. But think about that. A president has that authority. Kill anybody. In this room too. Well, I just decided that you're an imminent threat to national security. I don't have to explain why, anything. And when there have been efforts to try to identify what criterion presidents use before they exterminate somebody, state secrets, courts say state secrets, sorry, it'll give away, other people who could elude being assassinated, right? I said, wow. So you talk about the concentration of power in the executive branch. Yeah, it's certainly quite alarming. And with regard to the Paul Weiss, or you also had Perkins Coie, and you had before that Covington and Burling. And I say, it's the role of lawyers to be like John Adams defending the British soldiers in the Boston Massacre. That's their finest hour. That's why we're trained as lawyers, to risk our lives in order to advance the cause of justice. If you don't display courage, you shouldn't be a lawyer. You're just a hired gun. And I think that the culpability is as much on those who succumb. Trump is like the founding fathers said, yeah, Trump does what people do. They try to aggrandize power. So that's what's unexpected is have the defenders of justice to go and capitulate and say, okay, now we'll work for you. And that's what I fear, that it is the passiveness and the cravenness of the legal community that is dangerous, or not more dangerous than Trump. You have to stand up. I remember I do a lot of work abroad. There was a case in Pakistan when they had a dictator called Musharraf. And he was fiddling with it, trying to get rid of the Chief Justice there, and he didn't like habeas corpus rulings. The lawyers in Pakistan boycotted the courts and forced Musharraf from power. They wouldn't participate in the justice system anymore. I remember I was speaking out in, I don't know, somewhere in George Mason, and they had an international group, and there was a young lawyer from Pakistan. And this was the time, we're all into the Bush-Cheney era. And she said, my gosh, I thought lawyers here would be as brave as Pakistani lawyers. I said, well, they should be, but they aren't. And that's what I consider the fault of the law schools, especially the Harvards, the Yales, the Columbias, the Stanford. They don't teach ethics. I've written several articles for the Harvard Law Record saying, the worst abuses of executive power were architected by your graduates. And I pick the Japanese American concentration camps. John McCloy, Harvard. Francis Biddle, Harvard. Franklin Roosevelt, Harvard. That's all the people. The one who opposed it was who? J. Edgar Hoover, George Washington Night School, right? Okay, so that's where we are. I knew that, had a friend at one time, Harold Coe. He's at Yale. And he was a big defender of civil liberties at Yale, but Hillary Clinton appointed him as legal advisor when she was Secretary of State. And he was going up there and defending the idea that, when we destroyed Libya with our rockets and bombing, it wasn't war, because our pilots were flying at an altitude that didn't put them at risk. I said, okay, I guess the Enola Gay also wasn't engaged in warfare because they're real high and the Japanese couldn't shoot them down. They just dropped the nuclear bomb. I mean, really? So he defected to the enemy out of political loyalty. I believe Harold Coe, to be candid, he was aspiring to be the first Asian American on the Supreme Court, and he expected Hillary Clinton at one point would be there, and says, okay, I'll do your bidding. But that's not the role that lawyers need to be like Sir Thomas More. I'm not going to do it. And be willing to pay the price. It may seem a steep price, but I always think about the reason why we were emancipated from the bondage of closed minds, because Socrates took the hemlock rather than run away. So we should be steeled by that example.
So let me see you both. So let's follow up on Nina. I think asked she asked the broader question of how did we get here?
Yeah.
And in my introduction, I said that I took the Thomas Paine "Summer Soldiers and Sunshine Patriots." It was a phrase that he used, and I applied it to the Constitution. That basically where we are now is if you're a Democrat and you vote for a Democrat, right, and the Democrats get in the White House, and then you get the policies that you like, right, from a Democratic president, And you're not going to, basically people Democrats go silent on the Constitution. And the same thing with Republicans. When they win the White House and they get the policies that they like, they're equally silent. So it's not, so then the question is, you ask, how do we get here, right? How did that happen? It hasn't happened in American political history that any candidate, Democratic, Republican, or Independent, I think is run. Well, we had a Constitution Party. I think Schmitt's.
Yeah, but it was just, those were just words. You got to understand what it's easy. I say even the devil can quote scripture, right? Even an anti-constitutionalist can quote.
Well, that wonderful quote was the guy in the 50s. He's a Republican. He said, I don't have time to understand the Constitution. I'm too busy defending it.
Yeah. But I want to, let me amplify on your point, which I think is a very profound one. And that is, John, it's not just the fact that we've become more polarized politically. The reason is politicians in general are sociopaths. They crave power for its own sake. James Madison knew that backward and forward. Beginning at age 25, he's sitting Continental Congress, the Virginia councils. He saw up front, but he was the only one who actually had the biggest religious library as well, so he's highly intellectual. He graduates the equivalent of Princeton. But the more that the stakes grasping for power are greater, the more ruthless people will be. So when the government is a little tiny, it's got a budget of, $100,000, okay, why are you going to do something horrible to capture the presidency? Okay, it has some status, but there's no real power that goes with it. The bureaucracy, Elon Musk could blow it over in 20 minutes. Right? It doesn't exist. So as the government grew from a tiny acorn into this huge oak, the stakes are so much greater. We got a government now, an annual budget, $7 trillion. 7 trillion, millions of employees, civil servants, military bases everywhere in the world. So when you have a government this big, people will do a lot worse things to get the power than they would risk if it's really tiny. And that's why, in part, I don't want to say it's the total explanation, why the ruthlessness, why the sordidness of the political characters becomes greater. Because there's more and more at stake. And that's another reason why we need to downsize government in the right way, with proper process, proper oversight hearings. I think it's much too big, even if it's true that its benevolent designs are there, because we know that man in a state of nature, the strong do what they can, the weak suffer what they must. It's imperfect. But when you create a cure worse than the disease, and the reason why you have to be skeptical of government, it's got a monopoly of violence, it's got a monopoly of money. So whatever the private sector can perpetrate, it's a tiny fraction of what the government can do, especially when we now have the biggest military industrial complex in the history of the world by far. But I say part of the reason why we have this phenomenon and disregard of constitutional norms is because the stakes for violating the Constitution are so much better than they were before. There's something really big at the end of the rainbow if you flout the Constitution and you're part of the federal government.
So, in the election, the Trump and Kalma didn't run on the size of the federal government. It really wasn't an issue. And I said to a friend of mine in our Sunday morning coffee group, who's a very political player, I said, why didn't Trump, if he wanted to cut the size of the federal government, why didn't he mention it? And he said, well, he's too smart. That if he said, I think running 25% of the GDP through the federal government is a mistake. It's wrong, and we ought to, spend half that or a third of that. That if he'd done that, no one would have understood it. That was his argument.
Yeah. Well, in terms of the size of the government, it's smoke and mirrors out there No one really wants to cut the size of the government. With regard to the continuing resolution, it was the reason why Thomas Massey told me he voted against is this is Biden's budget. It really did. It shifted around out of $700 billion. It changed about $10 billion. And to the extent it changed it, it added money to the bloated Defense Department even more. But it didn't change anything. You wait and see, despite all the things that Elon Musk is doing, look at the next budget, the first budget that Donald Trump proposes. You see whether it reduces the last budget that he inherited from Joe Biden. That will be the test. Because right now, the military is asking for more and more. We're doing in more and more space things and AI, and it costs staggering millions, trillions of dollars. Yeah, you can get rid of the Cookie Monster or whatever, new 50 cents or something. You can get rid of that, but that really isn't the cause of the budget deficit that we confront today.
So, Nina, you could agree with, I want to, even though it didn't come up in the election, that I think it'd be better if we put less of the GDP through the federal government, right? And so you could agree with that as a policy, right? And then the question is, well, is it legal, right? And so if it's not legal, then basically we have to follow the law, and we have to change the laws in order to reduce the size of the government.
But we
right?
don't need to do that, John. I apologize for interjecting. Rand Paul of Kentucky has proposed, consistent with the Impoundment Control Act, a reduction of $500 billion in the federal budget. That's the norm, and there's ways to do that. You can rescind, under the Impoundment Control Act, prior authorized appropriations. At best, Elon Musk is claiming maybe $100 billion. So you'd figure if they're really intent on reducing the size of the government, they'd support the Rand Paul approach. Now, moreover that, it's clearly illegal. They haven't said a word supporting Rand Paul, because this is really about power, not money. They want to set precedent saying we can do whatever we want. The same lecture that Dean Acheson gave to Harry Truman in 1950, don't ask Congress for a declaration of war against Korea, then you have to go back again. Just do it on your own. That was Dean Acheson's advice to Harry Truman. Truman said, hey, that's a good idea. We'll just do it on our own. That's what this is really about. The other stuff is smoke and mirrors. It's power.
There's one other issue related to what you just. There's another issue related to what you just talked about, what happened in Korea when we called it a police action, not a war.
Yeah.
President Biden, on more than one occasion, said that we would go to war with China to defend Taiwan.
4 times.
And George W. Bush also made that claim when he was president. I don't either once or twice. That's an enormous grasp of power by the president to get us in a war with China over Taiwan without Congress having any say in what's going on here.
Not only that, but as you know, Pat, Section 3 of the Taiwan Relations Act says if there's an issue of security with Taiwan, Congress will decide. We'll talk about how to deal with it. So he's flouting. And you know who supported the Taiwan Relations Act? Joe Biden.
Joe Biden. So that's an enormous issue that we should be watching pretty closely, it seems to me. Thank you.
Yeah,
Here,
here you go. This follows on Nina's question. And I think the rallying cry should be make impeachment great again, because impeachment is really an empty threat. The only time that we ever got close to impeachment was when we had an unelected president who was a Southern sympathizer, and when basically there were very few Southern loyalists in the Congress, and the radical Republicans were almost able to get rid of Andrew Johnson, and failed. So we've had Trump has been impeached twice. Bill Clinton was impeached, and as long as you have a party with a third of the senators who are willing to support the president, impeachment is an empty threat.
But Bob, it wasn't empty with regard to Nixon. You know who went to Nixon and told him you got to resign? Hugh Scott, Barry Goldwater, the Senate. And they told him, despite they were Republicans, you're going to be convicted in the Senate.
I understand, but I'm talking about the actual process.
Go ahead, Bruce.
Oh,
Yeah.
I have a follow-on question, so go ahead.
Go ahead and answer.
no. I mean, I'm just saying that they were able, I mean, the Senate, at least at the time of Nixon, despite the party differences, was willing, or the Republican leaders say, you got no votes. You're going to be convicted if you come over here. So he said, I'm out. Now, that all politics is different at different times, but it shows that it can work, even though it's difficult, and I agree it's an uphill battle.
So, what do you say to Bob's point when I said that battle cry is we're not going to make America great again unless we make the Constitution great again.
Yeah.
We're not going to make the
No, I
Constitution
agree with
great
the larger
again
point.
unless we make
impeachment
Congress
is
great
more than
again.
a scarecrow. Yeah.
Making Congress great again means maybe make
Yeah,
impeachment. That's a good thing.
Because
can
I
put that
believe-
in. Because that, I assume that, right?
If you
when I say
have-
it, but
if
it's
you
not, it's
have-
not explicit.
If you have one precedent of a president being removed, impeachment and conviction,
So-
you're not going to have to use it again for 200 years. Even with regard to Nixon, and I serving in the Reagan administration, they were always lurking in the background. Hey, we can't do that. Look at Nixon. Nixon did that. We can't do that. You can be impeached and removed from office. Now, but that's 50 years ago, right? And now Congress is turned into an ink blot. So it really doesn't have much fear that they generate into the White House. But you're exactly right, Bob. We cannot make the Constitution great again by relying on the courts. Congress has to exercise the impeachment power. They only need to do it once, and they don't need to do it again and say it's because you're abusing your power. That ends the equation. Unfortunately, we don't have a Congress right now that's willing to do that, but the only way Congress is going to be willing to do that if the people, like everyone in this room, write in and vote and say, that's what your responsibility is. It's not going to happen by spontaneous combustion, I can guarantee you. I'm up there all the time.
Following on that very train of thought, one issue that's come up is about the roots of this comes down to, for some discussions at least, delegation and the degree of delegation. And it's undoubtable that the size of our economy and our population have grown tremendously since the Constitution was first written. And that dovetails with something that has been repeatedly heard not only in the U.S. Congress, but in state Congresses. I've talked to people that were served in state Congresses in the 70s and 80s, and one thing that caught my eye was they said when they served during that time, they still were surrounded by people that were salt of the earth. They had veterinarians, farmers, carpenters, general contractors, whatnot. And by the late 90s, that had changed. The constituency had changed completely, and it had changed. This limited sample claims it had changed largely because the complexity of issues and the tempo had increased so much that state legislature individuals were overwhelmed, and they just tend to give up and turn it over to lobbyists. If you accept that as a significant factor, where do we start to counter that?
I think it's a wonderful question, and I think the difference is understanding what the role and what the United States was created to accomplish, which is to make liberty our glory, not government control. That making everyone available to march to their own drummer, find their own fulfillment, understanding the right to be left alone is the most cherished right among civilized people. And what your description suggests is that the members thought that you only succeed if you create a new law, if you have new regulation. No, if you do nothing. Congress can do nothing other than emancipate, private energies, innovations that individuals come up with. That's success. Everybody thinks, well, they need a trophy. A trophy is, I had a bill named after me, right? That's what they're viewed as success. No, success is advancing justice, and justice, in large measure, I say, is trying to make everyone's station in life correspond to their character and ability. Nothing more. Not pluses or minuses government. Government is neutral on that score. And so, but the idea is created still today. Well, it's a do-nothing Congress. Let Harry Truman do nothing. Well, just being do nothing, maybe it's the right thing to do, because there is nothing to do other than let people free, right? So what's wrong with that? It's a total misunderstanding
Let him respond.
of why we were created as a nation, to glorify liberty, not to be anarchists, but to say, yeah, we do need laws to prevent predation, prevent invasion, but other than that, hey, we get people decide on their own. As long as they're complying with the law, they choose whether they want to play guitars, they want to make diamonds, they want to build manufacturers. Hey, that's their choice. And the more that we enable everybody to make that choice, we're a winner, even if we don't control any other country abroad whatsoever. We have influence abroad by example. Other countries want to follow it, that's fine. But otherwise, it's up to them. We're not the chosen people that tell them how to live their lives. That's what the framers thought government was supposed to be about. We're so divorced from that idea today. It's truly appalling.
There were many directions to go from my question, and I didn't make it clear enough. The second half of the message that I've gotten from talking to legislators is that it is finance-oriented, that they don't even think about writing bills anymore. They worry about their campaign finances. Yeah. And the world of the lobbyist has changed completely to making money for their industry by influencing the government. So you're completely right that individuals, legislators have completely changed their outlook from where the people who wrote the Constitution, but it's not entirely. The fault has become more distributed. It's the lobbyist world and it's the electorate who no longer insists upon those qualities. We get, what's the joke? We have the best politicians that money can buy.
Right.
Yeah. No, but see, all you have to do, do you think that there were lobbyists at the first Congress? None. All you got to do is tell a lobbyist, no, we're not for sale, they go away. The lobbyists there, the business people, they look on return on investment. If they're not getting anything out of government, they go away. The reason why you saw on the platform of the inaugural, you got Tim Cook, got Apple and Amazon, and all the wealth in the world, probably collectively 4 or 5 individuals worth trillions of dollars, right? They're all there because they want the government to help them out, shield them from competition. That's what it's about. And the reason why they are there is because they know it's more important to the bottom line that they're on good terms with the president or the executive branch than that they'd invent a better mousetrap like Thomas Edison. So they follow the money too. And if the legislature said, no, you're out of here, we don't do that, don't worry, they'd stop instantly. They're out there to make money. If they can't get the government to help them, they'll go away.
So the question that, Bruce, that hasn't been asked is, Nina was asking, how did we get in this mess? And then the next question, obviously, is how do we get out of it? And so we have a debate among ourselves, but I don't think the place to start is with the presidential election or the Senate races. It's just to start with the House race, and there are only 20 seats out of all the congressional seats that are really hotly contested. It's so gerrymandered, and Supreme Court has refused to reverse that. So what we need is a candidate in those 20, either a Republican or a Democrat, and who will take our Constitution first pledge, right? That they'll put the Constitution ahead of the policies of the party, right? So if they're a Democrat, they can still, be for abortion. If they're a Republican, they can be against it. If they're a Democrat, they can be for more environmental protection. If they're a Republican, they for less. If they're a Democrat, they can be for more health care, and the Republican for less. Or immigration, they can be, Democrats are looser on that than the Republicans. In other words, they can have more or less of all these things, that the policies that the two parties compete on, right? But if you've got a candidate, either a Democrat or Republican or an independent candidate that said, well, I will put the Constitution first, right? We the people, it's burning. And that the Constitution is more important than whether we have more or less of these policies that we swing back and forth on. And that becomes that wouldn't work in most of the congressional races. It would only work in those 20, or it could work in one of those 20 races where the candidate said, I will pledge now that I will do what the Constitution requires me to do, because if I win this election, I have to put my hand on the Bible and swear to uphold the Constitution. And I'm not going to commit perjury. So in a high school where we would go in, we'd work with a candidate, all right, on either side, and then they would say, I'm for all these policies of my party, but I will put the Constitution first. All right? Now that's kind of like what the Grover Norquist pledge, like you can't run right as senator, you can't run Republican without taking the Grover Norquist pledge on no tax increases. No. So this would be the equivalent of that. So that's what, now Bruce has a more, Bruce disagrees with that.
My observations are as follows.
You give him the purist, you give him the other, and then we'll ask. Ann has a question.
First of all, the Grover Norquist pledge is so popular because it doesn't require the signatory to do anything. No new taxes, but I'll borrow all the money in the world to get the government bigger and bigger and bigger. Now we have a $37 trillion national debt. So I told Grover, I used to lease space in his office. Yeah. Grover, every year you get more signatories and the government grows bigger and bigger and bigger, right? So maybe there's something wrong with your pledge. And he would never, I said, if you don't have a spending pledge, this is meaningless. Just borrow money, which is exactly what's happened. We're wanting something that, no, it means something. It means that you have to stand up and defend your constitutional prerogatives. It's not a get out of jail free card like Grover's pledge. Moreover, with regard to the possibilities, you may recall when Thomas Massie was the only one from Kentucky, he voted against the continuing resolution, right? And so Trump is infuriated. We talked, he does a wonderful imitation of Trump's voice when he calls him on the phone. And he says, oh, okay, now we're going to primary you. We're going after him, Elon Musk. They singled him out, they targeted him. Said, anyway, Thomas has a pretty good, safe district. So I called Thomas, text messaged him and said, let's make this a test, because Thomas didn't sign the CR because it was just a phony Biden continuation budget. Make it between you and Elon Musk and Trump. You'll win. And you can make it all about the Constitution and really complying with how the system's supposed to operate, no delegation. You do the rescission instead of just having the president decide he's going to impound funds. And now, what happened after I approached him is that Mitch McConnell said he's not going to run for re-election in the Senate. So Massey's kind of contemplating whether he should run for the Senate. He says, I don't know, how difficult that would be statewide in Kentucky. But I think that would, now Congress, remember, they're cow-like in the sense that they follow the herd. And if Thomas won, I am taking on Musk and Trump based upon the Constitution. He's flouting all sorts of limitations that ought to be there, especially the military-industrial complex. And you win, you'll get 200 votes the next day. Everybody will say, my gosh, he took on Trump. Because right now in Congress, they're all terrified. They all feel that if they do anything that even causes the tiniest burp in Trump, he'll get Elon Musk will fund the primary challenger. And they're all risk averse and craven enemies. Oh, can't do anything, so they're all silent. Behind the scenes, they're all very critical, but publicly, no, they won't do anything. So if you had somebody make the centerpiece of the campaign, Thomas Massie, who can't be accused of Code Pink, he's not AIPAC, he doesn't let AIPAC in his office, and he's not George, whatever his name is, the liberal guy, it's George Soros. He takes on Trump and Musk and wins. That'll dispel the fear factor in Congress, that causing them in part, to live in a crouch. With regard to if it's not Thomas Massey and one of these others, my view is that if you want to win, you only have the Constitution as the only issue you're going to address. Process is what I'm about. And master the process and say, you can come after me if you dislike me, but I'm going to make sure you can hold me accountable because I'm going to vote on war. I'm going to vote on the appropriations. We're not going to have all these delegations, national security things. I mean, right now, these tariffs, you know what they're imposed under? The International Emergency Economic Powers Act of 1977, which says, oh, whenever the president says there's a national emergency, according to Trump, now he can impose tariffs. First time this act has ever been used that way. There's another act in 1962, it's called 232, the Trade Adjustment Act, which says if the president's going to impose national security tariffs, he has to ask the Secretary of Commerce to prepare a report. There's due process. He can only issue tariffs on a product-by-product basis, not a nation-by-nation. He says, the heck with that. That's too slow. I'll just use the International Emergency Economic Powers Act. And the act, of course, never defines what a national emergency is. Whatever I say it is, right? I mean, the Trump, remember at the inaugural, we have an energy emergency. Really? We have the most productive oil and gas sector in the history of the country. We got an energy emergency? We're overflowing. We're exporting energy, right? And well, heck, if you can make a word mean whatever you want it to mean, like Humpty Dumpty and Alice in Wonderland, hey, this is where we are. So and I'm saying that running only on the Constitution and making the centerpiece and telling my opponent, what's X? What are you going to do? Are you going to vote? The war power would be the easiest way because the war power implicates trillions of dollars and the Congress now is AWOL and say, I will decide whether we go to war with the Houthis or with the Solomon Islands or to China. It's not going to be the president.
And I have a friend who, two friends, one's very right of center and the other's left of center. And this is all they do is politics. And the only thing they agree on, right? The one thing they agree on is that what Bruce said can't happen, that you could not go in any of those congressional races, or let's just take the 20 that are contested, or any of them, and say that I'm running on the Constitution. I'll put the rule of law ahead of the policies of my party. And with right, well, let me be more precise. That to make the process, to make the Constitution the battleground in American politics. They were saying that is a dead on arrival, won't go anywhere.
But my observation about that is
so that's the argument.
It doesn't recognize the way in which civilization has progressed and ideas take time to evolve. It may well be the first one who makes it the centerpiece loses, but it anyway starts the debate. Maybe the second time it happens, maybe the third time or the fourth time, but it has to start someplace. And I reflect, just think, the very first human being we don't know, completely anonymous, who first said slavery is bad, probably was executed. What do you mean slavery is bad? No, it's authorized in the Bible. We don't know who he was. Somebody had to start the conversation in order to convince people that slavery was evil. The same with saying women aren't chattels. Somebody had to say it, a woman or a man, probably ostracized, boycotted, killed, stoned to death, or whatever. But aren't we glad that person stood up? Because if that person never stood up and said anything, we would still be living in the Dark Ages. Somebody has to take the risk and get no credit for it. Otherwise, we're fossilized as a civilization.
So we're looking for that candidate. Any help you can give us on that? What's that?
Who the person was that said slavery?
No. Anybody who will want to run in a congressional race, because I think if it did happen that you did win one race, I think Bruce is right. I think it would be electric. It would be absolutely electric because all these the politicians are followers, they're not leaders, and so it would. I think it could be electric if you could win once in one district.
Yeah.
So we've talked about this before, but I think we've run out of time. But really appreciate everyone coming tonight and having this conversation.